good evening all my friends. Rather I would like to say my legal hairs. Recently, our brother friend has called me that I am the son of the bar. But I think that legally he has mistaken. Because I will share the claim. I will claim the share. So his share will be reducing. So think on Mr. Brother. A share is share. You should not generally be given up. Because unless there is a fight for share, we are lying. Otherwise, we may have to leave our profession. So, keep in mind my share. Don't forget. What share will be, I will definitely be. And I would like to take the share of knowledge. Not knowing very well. Okay. I think all the participants in this program are aspirants for the post of either the district judge or the GFC, or anybody is here to increase the knowledge or interact with the experience what they have for past many years of practice. Yes, my humble request is that keep our interaction alive. Don't shy. Whatever silly question is, we are here to clear our notions. Our legal notions must be clear. Because the newcomers have many problems, but I am seeing since last 70 years. Because what could I see from the dais that you can't see from outside the dais? The newcomers are having good command over language, but what I feel that they are lacking support and they are lacking the guidance. It is always talk of the bar why the newcomers do not join the office of seniors. If they join, they leave the office very soon. When I left this bar, I will share one story of the junior. When I left this bar in 2008, a young boy like you was a junior of some advocate I am not knowing, and within 6 months he left the university. I was a junior of my Guru Sri Gandhi for 5 years. So one day I met him because I was in contact with all of the members, all young, old, middle age, all groups were connected to me. So he met me and I asked him, will you join? So sir, I left the practice at the university. How many days are here? He told me I am 6 years old practitioner. Oh, very good. So just I, out of curiosity, asked him what you learned from this university. Sir, CPC. I was very much shocked to hear it. Within 6 months, he has got the command over CPC. I and my close friends were shocked. But we were taking care of the juniors at that time. We were taking everyone as a family member. I took him to the senior most lawyer who was the master in civil procedure code. Advocate Parsotkar will be knowing. He was at that time senior most lawyer, having around 50 plus years practice in mostly and purely civil side. I took him to Parsotkar Kaka and asked, Kaka, हा मुलगा म्हणतो की 6 महिन्यात मला सीपीसी समजली. मला म्हणत 55 वर्षात पण समजली नाही. So I want to appeal to you, don't haste. This is the profession of old age. This is the profession of patience. And if you wanted to become a judge, the foremost requirement, you know what happened then in the court hearts. The actions which the lawyer gives about the presiding of, what you say about their judgments, what you say about they are the basic things which are not useful only to your becoming judge, but in a daily life. So, to my mind, law is very simple. Many people say that it is a common sense. And one time when I used this word before one senior lawyer at Nagpur, I said that what is law? It's a common sense. He was a lawyer. He has immediately replied me. If it is a common sense, why everybody is not lawyer? Oh, yes, there is a sense, there is a point. So then I think more about it, or again and again I think yes, lawyer requires some special. I believe in myself that I am very grateful to God and lucky that I have become a lawyer. Because God chose me to become a lawyer and serve the society through my profession on getting return. That is, such is a wonderful profession. I would like to ask you first question to you. What is the primary duty of the lawyer? Be open, don't shy. What is your primary duty? What is your first duty to become when you become a lawyer? Defend your client. Yes. Second, next. Yes. To abide with law. To abide with law. Next. Loyal to your profession. Liar? Loyal to your profession. Loyal to your professional. Huh? Honestly, what you for? Honesty. Okay. Honestly, ethical profession. Okay. Next. Newcomers are not correct. Well, to my mind, the first primary duty of the lawyer is to respect the law. We must abide by the law, and we are the mirrors of the legal fraternity, and it is the first primary duty to my mind. I will not say that it should be the gospel truth, is to respect the law. Now there is again it will then what is the respect to the law, how it is to be dealt with, that we will not go into detail. Now let us start with our subject. The second thing which we have to see that a simple question may be solved very easily. Or in the daily routine practice is there. But normally the people come to us bring some complicated issues, more particularly in family matters. That is family matrimonial matters, property matters, and sometimes in contractual matters. There are many complications in which it is difficult for us to find out the solution. And that is the test of our advocacy. I will share you what the story which I read in the morning, I heard in the morning. मराठी सांगतो, मराठीत सांगितले जास्त परिणाम करत नाही. आज सकाळी मी एक मुलगी होती शर्मा नावाची, तिच्या वडिलांनी लिहिलेली गांगे शपथ. गांगे म्हणजे भीष्म. भीष्मानं घेतलेली शपथ याच्यावरती भीष्म हे भगवान श्रीकृष्णाचे भक्त पण होते. आणि ते भीष्म म्हणजे तुम्हाला माहिती त्यांना पितामह म्हणत होते. तेवढंच त्यांच्या जवळचा त्यांचा अत्यप्रिय शिष्य दुसरा म्हणजे अर्जुन. परंतु काय झालं, परिस्थितीने अशी पाळी आणली की भीष्माला कौरवांची बाजू घ्यावी लागली आणि कृष्णाने सर्वांना माहित आहे की पांडवांकडे गेले. पहिला दिवस युद्धाचा झाला. ही ज्या मुलीच्या भाषेत सांगतो, माझ्या सांगितलं तिथे ते छान गायलं, ते छान शब्दांचा खूप चांगला उच्चार केला त्या मुलीने. आपल्या युट्यूबवर आहे. पहिला दिवस झाला, दुसरा दिवस झाला, तिसरा दिवस झाला, चौथा दिवस, पाचवा दिवस झाला, सहावा दिवस झाला. रोज संध्याकाळी अशी बातमी होती की पांडवांचे इतके गेले, पांडवाकडे पिछाडीवर आहे. पण दुर्योधन काही सॅटिस्फाईड नव्हता. दुर्योधन फार हुशार होता, जे त्या कवितेत वर्णन केलेलं. तर तो भीष्माला म्हणाला, भीष्मा तू हे काय किडे माकोडे मारतोय रोज, आणि रोज म्हणजे त्या पाची पांडवांना तू धक्का पण लागू देत नाहीस म्हणे. दिस अनफेअर म्हणे. तुझ्या ठिकाणी मी जर म्हणे त्या याला ठेवलं असतं, कर्णाला जर ठेवलं असतं सेनापती, तर आतापर्यंत त्यांनी विधान घातली असते पांडवांच्या ह्याच्यात. तर जेव्हा कारण कृष्णाचा भक्त भीष्म पण होते. भीष्माला माहित होतं की कृष्ण कोण आहे, कोणाचे त्यांना माहित होतं. परंतु त्यांना काही मर्यादा सांभाळायच्या होत्या, त्या कळायच्या होत्या. असा त्यांच्यावर आरोप आला. आणि इकडे कृष्णाने शपथ घेऊन ठेवली होती, डिक्लेअर केलं होतं की मी या युद्धात शस्त्र उचलणार नाही, असे कृष्णाने डिक्लेरेशन होतं. पण डिक्लेरेशनला किती महत्व आहे, त्या काळात डिक्लेरेशन काही नवीन नाही गोष्ट. आता यांनी याची बाजू घेतली म्हणजे त्याच्याशी प्रामाणिकपणा झाला पाहिजे, भक्तीचा भंग झाला नाही पाहिजे, कृष्णांनी दिलेलं डिक्लेरेशन तुटलं नाही पाहिजे. हा किती मोठा कॉम्प्लिकेशन निर्माण झाला. परंतु दुर्योधनाने जेव्हा भीष्माला चॅलेंज केलं की तुम्ही 100% माझ्यासोबत काही भांडत नाही, आता 100% लक्ष ठेवा, कारण आपल्याला पक्षकाराची 100% बाजू म्हणावी लागते, हे लक्षात ठेवून चला. मग त्या दिवशी भीष्माला थोडस म्हणजे राग आला आणि त्यांनी म्हटलं की आज मी बघा म्हणे, आज कृष्णाची जी ते डिक्लेरेशन आहे ते मोडायला लावतो म्हणे, त्याला शस्त्र उचलायला भाग पडतो. आता भीष्माची ताकद काय आहे कृष्णाला माहित होत, कृष्णाच्या कानावर आलं. आता कृष्णाला प्रश्न पडला की दोन्ही माझे भक्त आहेत, अन्याय कोणासोबत करायचा. केवढा मोठा पेच प्रश्न पडला की जर कृष्णाने जर शस्त्र उचललं असतं तर 5 मिनिटात युद्ध संपलं असतं, असं आपल्याला सांगण्यात येतं. आता खरं काय खोटं काय आपल्याला माहित नाही. तर मग अशा परिस्थितीमध्ये बघा, एक भक्त याला येऊन ठाकला, त्याने अशी भक्ती केली होती की त्या भक्ताला कृष्णाने नाराज करता येत नव्हतं, की त्याला त्याच्या पोझिशनवर त्याला खाली दाखवता येत नव्हतं. म्हणजे त्याच्यासाठी शस्त्र वळवलं, विवादाचं जर काम पडलं, त्यांनी जर कंपेअर केलं तर त्याचा विजय होईल, परंतु अर्जुनाचा पराजय होईल. आता मी तुम्हाला ह्या गोष्टी सांगतो, ही कॉम्प्लिकेटेड सिच्युएशन कशी झाली बघा. कृष्णाची काय पोझिशन झाली असेल बघा, भगवान श्रीकृष्णाला कशी अडचण झाली असेल की इकडे याने जर शपथ मोडू दिली तर हा नाराज होतो, त्याची शपथ नाही मोडू दिली तर हा नाराज होतो, आणि भक्ताला नाराज कसं करायचं. भक्तांचं संरक्षण झालंच पाहिजे, जसं आपण आपल्या पक्षकाराचं संरक्षण करतो. साहेबांनी सांगितलं की टू डिफेंड द क्रिटिकल. तर अशी जेव्हा कॉम्प्लिकेटेड सिच्युएशन येते त्या वेळेला जी न्यायोचित भावना, न्यायोचित ज्ञान लागतं, ते कार्य म्हणजे आपलं कार्य आहे. असे कॉम्प्लिकेटेड इश्यू मध्ये आणि पर्टिक्युलरली न्यायाधीशाचं काम आहे. त्याला म्हणतात आपल्याकडे बॅलन्स जजमेंट, आणि हे तुम्हाला शिकायचं आहे. जर तुम्हाला न्यायाधीश व्हायचं असेल, मी न्यायाधीशापुरतं मर्यादित ठेवत नाही, हे तेवढंच काम, इक्वली इम्पॉर्टंट काम जे आहे हे वकिलांचं सुद्धा आहे. कारण तुम्हाला माहित आहे की वकिलांना काय उपाधी आहे, लॉयर्स आर द ऑफिसर्स ऑफ द कोर्ट. आता आपण ऑफिसर्सचा काय बाणा ठेवतो किंवा आपल्याकडे तो राखला जातो किंवा नाही, किंवा त्यात आपल्याला त्याचं महत्व कळतं की नाही, या भागाला आज आपण सोडून देऊ. परंतु कोर्टाला सर्वतोपरी मदत करणे, सहाय्य करणे, जेणेकरून कोर्टाचा निर्णय योग्य येईल, याची जबाबदारी फक्त वकिलावर आहे. आणि ह्याच प्रॅक्टिसमधून तो एक चांगला वकील होऊ शकतो. पुढे जर न्यायाधीश झाला तर तो उत्तम न्यायाधीश पण होऊ शकतो. तर ह्या ज्या कॉम्प्लिकेटेड सिच्युएशन आहे, याला लागतो अनुभव. आता कृष्णाने जो प्रश्न कसा सोडला हे मी तुम्हाला काय आता सांगत नाही, सगळे प्रश्न एखादे उत्तर देऊ नये. कारण आपलं जे बुद्धी आहे, वकिलांची बुद्धी आहे, तिला नेहमी खाद्य लागतं. ते खाद्य कुठलं, विचाराचं, थिंकिंग. आता ते खाद्य तुमच्याकडे मी घेऊन दिलेलं. तर सांगायचं तात्पर्य असं की अशा कॉम्प्लिकेटेड सिच्युएशन जेव्हा येतात आणि त्यातनं सत्य बाहेर काढायचं असतं, एक न्यायोचित निर्णय त्यात घ्यायचा असतो, तेव्हा आपल्याला गरज कशाची पडते. आपल्याकडे आपण फार नशिबान आहोत की सगळी संविधान आहे, शेकडो कायदे आहेत, आणि त्याच्याच चौकटीत आपल्याला वावरायचं आहे. परंतु हे केव्हा शक्य होईल? When it is possible, when you will read law properly, you will learn law properly, you will implement law properly, you will be able to place your case properly to the court, and you will understand to the question first. If you don't know the question, how will you answer? How is it impossible to answer? So there should be a method of studying law. There should be a skill of learning law, and you must have the skill of strong observation. This profession has very great importance to have a strong objection what happened around us. Unless you are alert in the court, may it not be possible to you to make a justice with your client. The client may have a good case, but your observation is loose and you are not so prompt in the profession, he may suffer for no cause. This is our responsibility. Nowadays we see friends, every lawyer likes to practice criminal side, criminal law. Civil side lawyers are very rare. This is the actual position. Everybody comes and joins junior criminal office. Okay, no problem. We will be discussing today on the subject as requested by the President, new BNSS Act, which was old, very popularly known as the Code of Criminal Procedure. Now the first question is, what is procedural law? Yes?
Procedure defines
It defines procedure. Yes. Anybody? Share. I will appreciate such type of participants. I am not here to show my knowledge. I am here to share with you everything. I may also commit mistake. Don't worry. I being the judge of the High Court, don't presume that I will not commit mistake. Mistakes are inadvertent. Those are possible and unavoidable. One. Anybody? Approach to trial. Natural law is called adjective law or law of action. It moves the law. It puts the law into motion. It puts the law in action. Hence it is said that adjective. This is the grammatical word. Adjective, kriya pad. त्याला काय म्हणतात? विशेष. This is an adjective. This runs the law, substantive law. So first we will start with this. Now friends, earlier this law was known as the Criminal Procedure Code. Now it has been named as the BNSS Act. So what is new in this act? What are the new features of this act? We share with. Now it is titled as a structure memorandum of the Criminal Procedure Code BNSS. What is introduced in this act? This new act, it is firstly it is introduced the electronic proceedings. What is that? Trials, inquiries conducted through electronic mode. According to this fact, the courts are insisting come on online, file online. This is the introduction of this law. The secondary is to make the transparency in the investigation and trial. Radiography is made applicable. Many things. Particularly where seizure. But there is a great possibility of tampering in the seizure. So that the accused may suffer if the evidence is not genuine or untampered. The second, EFIR. You know that EFIR is available. Zero FIR. This is also a provision made specifically. Secondly is about forensic evidence. It's a great and important evidence that requires in a criminal trial. Now it is made mandatory in all the trials, which is punishable with not less than 7 years or more, or not less than 7 years or more. What is to be collected? The scene offence, that we call as the scene of the offence. Scene investigation, if the crime is registered in front of this court hall, that is the scene of the incident. That must be examined by the forensic experts. What is the object and the purpose behind that, and how it is to be done? Should we wait till the forensic team came from Bombay, from Nagpur or Amravati? No. It could be immediately videographed. What is this type of evidence? This evidence is called as a trace evidence. This is a trace evidence. Most important evidence is that this is a trace evidence. Next is, friends, police custody. You know that period of police custody has been extended. Earlier it was 15 days and 30 days. It is now 60 to 90 days. You know better that. This is the extension of the police custody. Why it is so? Is it helping the police only? No. It is helping to investigate properly and to make a justice with the person injured or the victim. The objective is him, not the police accommodation. Next friend is absentia trial. Do you know about the absentia trial? There are large number of cases of pain in the court because the accused is absent. You might have heard the story that an accused residing just beside the police station, and after warrant the police said that they are not getting him, and actually he resides just beside the police station. They are the stories. So what happened? How to control? Why the victim should run after him? When he will get the relief, when he will get the dispute of the matter. Therefore, this provision has been introduced, absentia trial. Against whom it will go? Against the proclaimed offender. Once the offender is proclaimed, then trial may proceed in his absence and the judgment that matter will be disposed of. This is new. Now the one new punishment is introduced, that is community services. Community services earlier before this amendment or introduction in the provisions of law, many of the judges have imposed such type of community services. But there was much hue and cry. There were some community punishments were differing or showing him low down in the eye of the society. Therefore, it has been introduced. Some section is given. What is that? The idea behind introducing this punishment is based on the reformative theory. Let him learn what mistake he has committed. Therefore, these community services have been inserted as the punishment. Electronic procedure. What is the electronic procedure? Do you have any idea about it? It is the trials, witness examination. You see that? You can examine the witness residing abroad via conference. It is most helpful in matrimonial disputes, in contract matters. The big busy persons may be called there. You can save the time only on the absence of the transfer of the investigation officer. If the investigation officer is here and in the meantime is transferred to Kolhapur, he need not to die. He can directly appear before the court online conference. This is a great benefit to all us. What is the benefit of such type of benefit? We could save one reservation in railway station. We could save the reservation in rest house. One could save the services of the local police. We are the benefit of this such type of facility. So we should be made acquainted with it and we should accept it wholeheartedly. Now the question is always there. What about the rights of the victim? How long the victim should be in the court premises and spend the time, valuable time. And the greatest suffering of the victim is to sit before the court all day and every people watch at them. Take the case of Pakso matter. A small child has to come to the court for recording the evidence, and at 11th hour at 4 p.m. we say, sir, we are not able to proceed the matter. What are the feelings of that child? Not child, every victim, though he may be plaintiff or defendant, it must be respected. There must be timeline for their redressal of their grievances. Therefore, it can be introduced. First of all, this is the new introduction of the procedure that the victim shall be intimated or updated within 90 days. Otherwise, in old law, this facility was not available. The complainant was not knowing what is happening with the matter. The individual was not knowing what is happening. When the prosecutor was calling him, that time they were coming and going. Even they were not aware of what the judgment is passed. So this is the responsibility imposed upon the court to intimate them, update them. And we have experienced, friends, कि for want of forensic reports, the matters are lying for years together. So it is a mandatory provision that the forensic reports must be submitted within 7 days. Next is, now the question, although it is a hard subject in the court of law, courts and the bar. Oh, that judge has heard the matter long back and till now delivered the order or not passed the order. My client is expecting the blood. He is really asking me what happens there, what happens there, what happens there. But what could I say to the court that we are not to passed? So this law is mandated that the judgment should be delivered within 30 days from the date of argument. Next. Initially the old practices will remain about the handcuffs. Because handcuffs were not allowed. Because it was lowering down the image of that accused. Because in future he will be acquitted. He is just an accused. But sometimes we have an experience that many of the accused either ran away from the custody of the police or they have attacked the victims. So this law is introduced in cases like rape, acid attack, organized crime or repeat offences. They must be handcuffed. It is made legal. Now, we have large number of the under trial cases. How long they should be kept behind the bar? But sometimes it may be possible that it may give the adverse advantage to the hardened criminal. So this provision captures that there is a restriction for releasing under trial for personal bonds are tightened to exclude those with multiple pending cases or life imprisonment cases. This is the new provision introduced. They should not get as a matter of right. If there are multiple cases, we should not be released on personal bond. The evidence procedure has been expanded. How it is? 5 samples is required. Earlier it was procedure was very complicated, probably there was no provision. Now the courts are empowered with power given the authority to ask the person connected with the trial or offence or dispute to give the sample by sample or handwriting impression or signatures. So it is made very easy. For that one need not to call the expert and then follow the procedure, take him to somewhere, immediately quote the order that will be taken. Earlier there was some provision for section 70 of the rules and that is still there. But that is for another purpose. This is all about the new, but we say new in BNSS Act. Now we are going to compete for the post of the judicial magistrate, chief judge, and particularly the district judges. Because district judge advertisement with large number of vacancies have been advertised and many of aspirants are going there. So my humble opinion about this is that this competitive examination is not less than or as good as battle. It is a battle. And you must know first the battleground where you have to fight. And unless you know the each corner of the battleground and the rules of the battle, you may not win the battle. What is this step of competitive examinations are? In simple words, it is nothing but a memory test. What you remember? They will put the question from the book, law books, and you will have to remember and write it. But as I said you, there are rules of battle. There are rules of this competition. And those are declared. Those are not kept undisclosed. The pattern, what type of questions will be there, what will be the subject there, how will be the marking pattern, how will be the negative marks, and how much experience is required, all your qualifications and required knowledge is declared. It was never undisclosed. But what I experienced, many of the aspirants go to the competitive examination without knowing the pattern of that examination. If you want to enter the battle and come live, you must know the pattern. That pattern, unless you know, I am of personal view that it will not be appropriate or a scope for success in your competitive examination. You only need to read the law. There are certain rules. So I would like to discuss with you what is the pattern of the district examination. What type of questions are asked? Normally, because this is the expectation of the employer. The employer, if you wanted to post on such a particular post, he will expect something from you, that what minimum knowledge you should have. And you should also know that what minimum requirement should we have. For that, what preparation you should make. Only just reading law, you are daily reading law. But now you are reading the law with a purpose to compete with your brother, your sister, your colleagues, your senior. You must know the law. So hence with the permission of the President, I would like to share my opinion on the pattern of the examination for the district judges. Because soon after completing 7 years, a lawyer becomes competent or eligible to become a district judge. 7 years, I think. And 7 years, how you can pass? Very easily you can pass even in the bar. Bar has that magic power. You don't understand how time is passed. So, but the question is, while passing the time with the bar and bar members, what we all learn? How expertise we have got it, or how expert we become. So, let me allow to share my opinion to make you sure that you should fight better or increase the chances of success in an examination. Therefore, please understand what is the pattern for district judges. Sorry, I have no any pattern question papers for judicial magistrate. If you call me again, I will come with that also. What are questions are put in the matter? First, the district judge is a post who is just next to the High Court. So every order goes to the High Court. So it is expected that he should have knowledge as good as the judge of the High Court. Because many powers of district judiciary, so far as these laws are concerned, excluding the constitutional powers, are not so different. If you will take a matter of civil procedure code to the High Court or Supreme Court will also read that law only in civil procedure code. They will not require to read another law. So what is our standard? We are equal to them, or we are equally controlling it. But officially there is a subordination. So those are having more power. But legally some powers. You take an example of revision. 397 CRPC, old. Same power is with the court. You say that, you see the power of the appeal. Same section applied to the appeal before the High Court in CRPC. So you are expected to have that much knowledge, that much command over the law. So how it is to be tested? First, the first test would be how analytical you study law. How do you analyze the law? Therefore, the question pattern is there is one. One is assertion and second is reason. In this question pattern, what is asked? Whether the assertion or reason is correct or true, or the assertion is true, but the reason is not true explanation. So this type of question you should really keep in mind. Why? For it is the test of your analytical legal knowledge. So that may include the definition of the law, that may include the statements. So you should study like this. Read the questions, you will understand. This is the first type of questions what I see in one of the paper in 2019 of the CJ. Then next is, there are many questions asked on Indian Penal Code nowadays. I observed that in some of the questions the derivatives of the sections are asked. Some correlated questions of the law are asked. Their effects have been asked. This type of questions come about the law. All laws. Now I am not Indian Penal Code. It will become, it will be family matter, it will be contract, whatever it will be. This is another type of questions there are. Sixth, effect of act and action. If you do something, what is the effect and what is the action for that? Such type of questions are there. You need to study the case, that question paper first. Then, every law gives the rights. Laws are the written rights of the parties as well as their responsibilities and duties too. So there are the questions, there may be the questions on the right of the accused. What is the right of the accused? You should learn it, you should read it. These are the rights. Right to produce before the court within 24 hours. It is the right. Right to seek the bail. It is the right. Right to ask for the legal assistance. It is also the right. Right to ask for medical assistance. It is the right. Right to ask for the copies of the document. It is the right. There are many like such rights of the accused. So this type of questions are also I find in the question paper. Then procedures. How to get this right? Where to go for right, asking right? Which code has jurisdiction? What jurisdictions are restrictions? Jurisdiction and restrictions. What are the duties of the court? What the advocate should plead for the accused or the parties to the suit? Then what is the procedure? What is the procedure of filing bail application? What is the procedure of filing revision? What is the procedure for asking the property return? What is the procedure? Their procedure should be a uniform. Wherever you go, the same pattern will be there. Then this procedural laws are enacted. Then we always have the court, my lord, your honor, you have no right to pass the order. You say, why? When you say that my lord, your honor has no power, court never lied. He said, yes, to point out me how my duration is outstanding. They just never take it seriously. It is his habit. If it becomes that, you will take it very lightly. चलता है मेरा पावर पूछ रहा है बराबर है. The power of the court. Normally what happens, the lawyers do not read the jurisdiction and the powers of the court. Normally I experience. But they say that this is the law of the court, whatever it is. No. It is the first duty of the lawyer to know what are the jurisdictions of the court, what are the powers of the court. Else there will be dilemma. There will be havoc. A session will be decided by session, magistrate. Then the magistrate case will be decided by the session court. He has power, but no? Session court has power. If the offence triable by some session court with magistrate court, the session court has to deal with that magistrate court. So this power of the court is very important. It guides us which door we should knock for the justice with our client. Next, then action of the court. Will you satisfied that merely passing the notice is suffice? We will ask for the fruits. What is the action of the court? If the act is not coming, issue warrant. If the complaint is not coming, dismiss complaint. If the directions are not followed, take action. These are the actions. If you move an application, you have a hearing, decide the application, lead builders, allow to lead builders. These are all the actions. These questions are also asked there. Therefore, many questions are asked. Because when you read the law, you might be knowing that there are various exceptions to various sections. So these exception clauses are particularly asked in this question, in this examination. So you should read the exception. What is the exception? Then sometimes the proviso clause to the section. You must know what is the effect of the proviso and what is the exception. This I am giving an only just a information to you what you should read for the post of distinction. Sometimes there are explanations to the sections. You should know why that explanation is. What is the purpose of that explanation? This section itself is running in 10, 20, 25 lines. But why there is the explanation? What is the meaning of that explanation? You should know. Therefore, Mr. Limitation. First of objection of the lawyer is sir, the suit is barred. Second is sir, this is barred by law. We take a big objection. But we should know there are many limitations provided in the special enactment also. Not only limitation act. So what will prevail? You will ask, you will be tested on this point. So you must know limitation. So you have to read, you have to make a compilation. I am making that compilation. I am getting short of time. I am making compilation on this type of questions. Limitations. Under all laws, what are the limitations? Legal disabilities. What are the legal disabilities? Do you know the disabilities? No? Don't know. Legal disabilities minor, insane, lunatic. These are all legal disabilities. Juvenile. All. These are the legal disabilities. But where those are and what a treatment of what right is conferred upon them. Such type of questions are there, what I observed. Then we see that then some questions are on the constitution are asked. What rights the constitution conferred on the citizen? We say that fundamental rights. What are our duties? On these rights there are certain questions. Then remedies. You have fight with this madam, what is my remedy? What is the remedy? Sometimes the remedies in the constitution are intervals. And sometimes some remedies under the constitution are general. We say that judgment in persona and judgment in rem. The rights, sometimes there is a dispute between state and state. And in provision, whatever disputes are there, how they are dealt with, these questions are there I find in the question paper. Then what is the dispute, how the dispute between central and state will be dealt with, what is the article? There will be question on this point. Next, what are the powers, legislative powers? What law the state will enact it, what law the central will enact, and what law the state and central will enact. And what is the effect of conflict? Such type of questions are there. Then many questions are on legal maxims. You should learn, you should read the legal maxims. But many times only legal maxims are put and its meaning is asked. And it is asked under what law this is the maxim. So you should learn it. Then many questions I saw that on the basis of the landmark judgments. Some questions were that what is the judgment of Vishaka? You know better. What is Vishaka? What are the guidelines? Exploitation of the woman at the workplace. Till though the act was enacted, these guidelines were kept the law. There are many such judgments. And they will give an example. Constitutional framework, structure, constitutional structure. Then powers of the High Court and Supreme Court. Article 226, 142, 32 of the Constitution. These questions are there. I am not telling you of my own. These are the questions may be asked. Sometimes your fundamental rights may be suspended. Emergency. Then question is that who will and under what circumstances? Huh? No. Who will suspend your fundamental rights? Again, President and the Supreme Court. But the circumstances are different. So you wrote that. Supreme Courts and High Courts review power. What is review? Not this review. Review of the law. Legal review. What are the powers? What are the restrictions? What are limitations? Many questions are asked on jurisdiction, particularly inherent jurisdiction. You know that there are three types of jurisdiction. Everybody knows that. I will not go into depth. But questions are on the jurisdiction of the court. Then territorial may be there, but particularly here questions are asked where this subject would lie. Then the questions are on right attached to the land. That we say that usually right. There are usually questions. There are questions on contract act also. These questions are in the form of rights and liabilities arising out of the contract, heirship, marriage. These are the rights and liabilities arising out of some relationship, juridical or natural. These are governed and looked after under the different acts. So these are also the questions we need to focus on. Then our day-to-day business of transfer of property, take and give, व्यवहार ज्याला म्हणतो ना आपण सामाजिक व्यवहार, ते कसे करायचे? How the documents are to be created? What documents are required to be registered compulsorily? How the document is to be presented? What are the contents of the document? You should know this. And if the documents are defective, what are the remedies? Such type of questions are there. Then, effect of judgment. What is about effect of judgment? If a judgment is passed, whom it binds? The parties in the suit. But there is a provision that the party who was not party but affected he may prefer appeal. This is the effect of the judgment on the parties and other than the parties. Whether the judgment is voidable, whether this contract is voidable, whether this judgment is void ab initio. Even that judgment is void ab initio. Then suppression of fact, effect of the suppression of fact. Then a judgment delivered against the precedent. Then which we normally do not get, the fruits of the decree. Most neglected part of our system is execution of the decrees. I am not blaming the court only. The lawyers are also not interested too much in the execution process. We must get the fruit. On fruit question, there will be question. What are the limitations about this execution against whom this decree will be not executed? When that decree becomes inexecutable, such type of questions are there. Then there are laws which give the immunities. Whom the law gives the immunity? Woman, weaker section, minor, lunatic, that I said that the legal disability. There are special laws for the woman, children, United Justice Act. It protects the interest of the child. So then there is a religious protection also there. Immunity for dancing lady. There will be a question on this point. You must be knowing, you must know the classes of the litigant. Accused. There is unsound mind, lunatic, what are the juvenile, child, woman, child in home also. There are right for the child in home. Some laws are there that they are giving special protection to the members of the society. Atrocity Act, POXO Act, Human Rights Act. These are all laws. There may be a question on this point. So this is all about what I could say you about the preparation what you have to make for entering the battle of the competition for the post of district judge. Let us now turn to our subject because this subject is very vast. In one session, it is not practically possible to finish. So only some broad things we will discuss today. If needed, we will continue the class. We will continue our this session to understand the law not for the purpose of examination, but for to become a good lawyer. Because it is the need of the time that people are searching for good lawyers. What is good lawyer? You define it. I will not define. Because what people say about us out of the court premises or after our office is the real test of our goodness. What is really you are a good lawyer or what type of lawyer you are. So, friends, question is why procedural law is important. We already discussed about it. It is important, crucial, because it ensures what procedure law ensures due process and fairness. How is due process? You have to come by some particular process. You cannot directly go and throw the petition on the table of the court. There is a procedure. Go to the clerk, register the matter, pay court fee, get his examination, give register address, give copies for other side, take the copies from other side. And what this indicate? This indicates the fairness. Whatever I am attacking on you, this is my weapon. Then equal treatment. Once the litigation is filed against X person, Y person must get the equal treatment to know what is against him. The right of the accused to know what is registered against him. This is the procedural law. Again, what it proceeds? It provides the legal consistency. For legal consistency, procedural laws are equally important. Then I will discuss about the filing of petition, hearing, opportunity, etc., etc. And the foremost important requirement of this law is the enforcement of the substantive law. Substantive laws could not be enforced unless the procedural laws are enacted. I will give an example why procedural laws are important. My brother has purchased a Mercedes car and it is parked in his courtyard. That is a substantial property for him. We say that substantial law for Mr. Parkerkar. Mercedes is parked in front of his courtyard. When he will enjoy it, unless the driver comes, he sit on the driving seat and बटन लगाएगा, चाबी लगाएगा, जब तक चाबी नहीं लगाएगा, ड्राइवर में आएगा, तो मर्सिडीज की वैल्यू क्या है? तो प्रोसीजर तो ड्राइवर को पता है, तो बात करके आपको ड्राइवर लगाना पड़ेगा, नहीं तो खुद को ड्राइवर किसी पे बैठना पड़ेगा. ऐसा है, वो सब्सटेंशियल लॉ पढ़ा है, प्रोसीजर ही नहीं है. इसलिए प्रोसीजर लॉ का इतना इंपॉर्टेंस होता है. व्हाई दिस इज प्रोसीजर लॉ? बिकॉज द सब्सटेंशियल लॉज आर एनफोर्स्ड only through the procedural law. This is the importance of that. This regulates the evidence and trials. We know various stages of trials, how those are going ahead, how the evidence are recorded. For this purpose, it is so significant and important. Why these are done? Why do we record the evidence? Why we give opportunity to both sides? The sole purpose of the court as the law is to find the truth. Both parties put their case, trying their very best to bring the truth and throw the ball in the court hall. But don't forget, after throwing the ball in the court hall, be with the court hall till the judgment is delivered. Okay? This procedure guarantees the accountability. If something is to be done by Mr. President, that is a procedure. He must declare the election on a particular time. That is his accountability. It guarantees accountability to you all voters. KRC's term is over, he will declare election and I will contest now. So this guarantees this accountability. It also provides for remedies. If proceeding would not work, you will move a motion of no confidence against him, taking 50, 100 signatures, which you can get very easily blindly signatures. But they are procedural remedies. So you must have the right procedure, right to appeal, right to review, right to appeal. So these provisions are there. So you should read law this way. Bifurcate into columns, subjects, because this act contains 39 chapters. 39. Act is divided in 39 chapters. So which act, which chapter deals with what subject, and how many two acts deals with one subject, you should make it in column wise. I am trying to make it if time permits before your examination. So you will be able to understand what type of matters are dealt with under the law. Once you learn it, if your question come before you, you will quickly remind it. Yes, this is that. If you are not knowing what are the dealings, stage-wise dealing, disposal of property, seize property, then whom it is to be given, who has right to receive, all is given there. So review is also your right. If you feel that the judgment delivered by the court needs review, that some important aspects are avoided or not pleaded, you have a right to seek the review. And asking review to the court is no wrong. The courts are very open to correct their mistakes. So these are the review powers. These are provided in the procedural law. When we start reading this law, having 39 chapters, the first chapter deals with the structure of the court. You know the structure of court. How many types of the courts are there? What are their jurisdiction? What are the powers? What is their period in jurisdiction? What are their limitations? What are their jurisdiction? So this first begins with the establishment of the court. This is the first chapter in most of the cases and criminal procedure court. Sessions court, special court, judicial magistrate court, senior division, civil court, and magistrate of second class. So this, and as soon as these persons are this structure is formed, just appointing you a judge is not fruitful. You must be given the power, you must be given jurisdiction. So immediately the court deals with the jurisdiction. So you should read like that. Then when there are different courts, every court has their own power. I may have different power. President may have more power than. But Karkar may have power, another power. So you must confer a specific power on each court. So these are provided in this act. Secondly, you have to read the law. When you are acting before X court, you should be well armed with the knowledge or information or the provisions what powers and jurisdiction this court is. So you may be able to deal your matter very properly. And now so far as the criminal courts are concerned, what is their basic powers? How much punishment they can impose, magistrate, CJM and the session. First foremost important है किसको कितने दिन भेज सकता है. सर 7 साल के ऊपर नहीं भेज सकते आप. इसमें 10 साल का कन्विक्शन है, ऊपर नहीं कीजिए. ये आपके पास का नहीं है, आपको अधिकार नहीं है ना. तो पनिशमेंट के बेसिस पर भी उसका इलेक्शन किया जाता है. सेशन कोर्ट का भी उनका पनिशमेंट के ऊपर होता है. लेकिन सेशंस कोर्ट को अपीलेट पावर दी है. दे हैव अपीलेट पावर्स. So merely filing appeal does not mean that they can do anything. There are certain limitations, restrictions. In appeal, what they can do? In an appeal, can appellate jurisdiction court against conviction reduce the sentence? Why? Huh? exact answer, correct, very correct answer. That code has no that power. But the same code has no power. When? When the appeal is filed. Particularly it is about enhancement of the power. In conviction, court may reduce the conviction of the reduce the sentence, but can't enhance. I'm sorry. So, but that court may enhance. But when the state or aggrieved party prefer the appeal for enhancement of the sentence or questioning the sentence, then this court have also power of revisions. You know better. Only knowing that this power has court has a power of revision is not suffice. You must know the limitations of the revision, the subject falling under the revision. You need to read it. Special courts, you know, POCSO code, NDPS code, atrocities code, many codes are family codes. These are all special codes. What is another agency? We need to run this procedure law. The foremost first and agency comes into the criminal law is the police. We need police. Without police, we can't run the court. We need the lawyer. Without lawyer, we can't run the system. We need the ministerial staff. Unless the ministerial staff is there, how the court will run? We need everything. All the society members connected with it, and particularly some society part. Police is first. What is their duty? The primary duty of the police is to investigate the matter and collect the evidence. So you should learn, you should read what are their limitations. Because no law gives anybody an absolute right of power. Keep in mind, in democracy, no one is boss. No one is supremo. There are restrictions on power. Their duty is also to maintain the law and order. These are very simple questions I am telling you. But I am just giving you an idea to how to read the law. Not only for the purpose of examination, but for becoming good lawyer. Then you know that they have the powers of arrest. What are the limitations? You should know. Protection of the accused. Court act. Yeah. Please come. No, please come. We welcome our brother Judge Mr. Dabade. He has saved valuable time to share the dice with us, and I hope he will write to us if we commit any mistake. मूर्ती छोटीच पाहिजे, कीर्ती महानच असते. So I welcome him for on behalf of the Bar Association, and I am a member of the Bar Association. Okay, guys. Okay. So we are on the police because everybody has a particular image of the police as per their experience. So, but we must know the powers of the police because those are tested before the court of law. They have no absolute powers. That chapter we must read carefully because the crime investigation begins from the police station. Every fairness, every proper investigation is expected. Why? Again we will come on the same point to make a justice to the litigant, at least to come to the proper conclusion of the dispute. What are their duties? You know that final report, producing the production of the accused before the court within 24 hours, timely production, taking care, etc. etc. Now the second important part of the judicial system is a lawyer. It is said that the lawyers are the wheels of the golden chariot of the judiciary. If lawyers are not there, the chariot would not run. They are equal. You know the effect of your boycott. What happens? The court becomes idle. But mere lawyer is not sufficient. The law expects that the lawyer should be able to assist the court. And he is the first man to bring the facts to the notice of the court. Because what litigant says to him, he will not say anybody. He should be the best analyzer of the instructions. What is the primary duty of the lawyer? एकच गोष्ट तुम्हाला सांगतो, मराठी सांगतो तुम्हाला कळवून. लॉयर तो हुशार की त्या पक्षकाराकडनं अत्यंत महत्वाची इन्स्ट्रक्शन त्याने केव्हा काढली ते पक्षकाराला कळू नये. आपल्या सिनियरकडे बघा, अशी काही माहिती घेतात ते की त्या पक्षकाराला चक्कर येतो. एकदा माझ्यासोबत पण झाला, मला पण आनंद झाला. एका केसमध्ये मी मॅट्रिमोनियल केसमध्ये डिस्प्यूट करत होतो. ते पक्षकार सकाळी आले. आता पक्षकाराला असं वाटतं मी काय सांगू काय नाही सांगू किती सांगू, वकील साहेबांनी किती माझं ऐकावं, नुसतं ऐकत राहावं, दुसरं कामच करू नये असं मला पक्षकाराला वाटत असतं. कारण वकील बोललं की त्याला प्रवचन दिल्यासारखं वाटतं आणि ऐकलं की त्याला वाटतं आपण प्रवचन घेतोय काय. ती एक केस चालवली, मला त्यातली एकच इन्फॉर्मेशन महत्वाची होती. तर त्या मॅट्रिमोनियल डिस्प्यूट होता तो, त्याच्यामध्ये मी त्याला त्याच्या समाजाची, कारण आपल्याकडे समाज सगळं चालतं, किंवा लग्नाची पद्धत कशी आहे याचा मी त्याची सहज बोललो आणि तो विसरून गेला मला नाही. आणि मी क्रॉस केली त्याच्यावर, तर मला माहिती होतं तो मुद्दा त्याशी कनेक्टेड आहे. मॅरेज डिस्प्यूट होतो. तो बाहेर आल्यानंतर तो पक्षकार म्हणून साहेब म्हणजे ही माहिती तुम्ही कुठून काढली म्हणून, तुम्ही कसं सांगितली, काय सांगता राजे म्हणे, तुम्ही काय विचारली, म्हटलं सकाळी तर विचारलं तुम्हाला. तर दिस इज द स्किल, म्हणजे मटेरियल इन्फॉर्मेशन कलेक्ट करून त्याचा कसा यूज करावा यासाठी वकिलांची गरज आहे. आउट ऑफ कोर्ट हॉल काय असतं, त्याला कसं आणावं, किती आणावं आणि प्रॉपर वेळेने कसं आणावं यासाठी वकिलांची खूप खूप नितांत गरज असते. कारण वकिलांना विद्वान नावाची पदवी आहे. ही पदवी कोणालाही मिळत नाही. लॉची डिग्री आली की विद्वान वकील साहेब असंच म्हणावं लागतं. So they have a great role to play in a criminal justice system or the judicial system. So we have already discussed about their primary duties and what is the responsibility. We should be very very careful while making a statement before the court, because his statement binds his litigant. Provision is there, you know that. So you should be very careful making statement for and on behalf of the litigant. Don't put him to loss making irresponsible statement. I am saying that. Don't make any irresponsible statement to the court and don't damage your image. This is not the part of a CRPC, but I am telling you. We already discussed about the judicial stuff. Now we will discuss on the trials. How the trial begins, the filing process. Before supplying the copy, the magistrate has to issue process under section 227. What issue process? What is meant by issue process? Please read it. I will not go in detail because we are running late. Then, when the work of the trial, sessions trial begins only after the commitment of the trial. Till then, session court can't do anything. Because most of the cases subject to accept special laws. The charge sheets or these reports go to the session court through the magistrate by a committal order. Then during the trial, the court has power under section 228, dispensation of the presence of the accused, exemption. This section 228 deals with it. If you wanted to become a good lawyer, I will request you all to write the section in your AV application. This application is so and so. It will make you read law daily, and you will have good command over the sections. If the code will ask you under what section I should do, so you will be able to say, sir, this is the section. So start practicing writing state application in the order so and so, application in the section say so and say so and so act. Then in petty offense, there are many types of the trials. You know that we will not go in detail. Then I will already discuss with you supplying the copy. Not only the magistrate, but sometimes the session court may also supply the copy.